some questions in the chat room, but for the most part, we think we have a pretty good agenda of what's going to happen, and hopefully we'll be able to answer your questions before they even come up. So I want to again thank everybody for being here, and with that, I'd like to introduce Judge Diane Sullivan. So, Your Honor, will you please introduce ourselves to your audience and share a little bit of your background and the run-up to you to be elected Justice of the Peace?
Sure. Can you hear me okay?
We got you.
Okay. All right. Wonderful. Hello, everybody. I'm Diane Sullivan. I am a Justice of the Peace in the Las Vegas Township. I was elected in 2008 and took the bench at the beginning of 2009. So I am in my 12th year of being on the bench. Before I was elected to the bench, I practiced civil, real estate, and business litigation for about 16 years. I practiced at a large law firm that was called Jones Vargas. Before that, it was Jones, Close and Brown. I became a partner there in about 2000. And then in 2004, I opened up my own law firm with another partner. And we had kind of a boutique law firm, again, handling basically business, real estate, and eviction litigation. I practiced a lot in district court and justice court before I took the bench. And that about covers me. I mean, I want to tell you a little bit about what I do on the bench. Right now, for the last 10 years, I have handled a full criminal docket. But when I first became elected, my priority was to try to clean up the civil work that was being handled in justice court. So I did handle a full civil docket for the first year I was on the bench. I also recruited Judge Melissa Saragosa. If any of you have been in civil court here or eviction court, you might know her. I recruited her, and now she's kind of our resident agent civil judge here because she's been doing civil for several years.
That's awesome. And then Judge Sullivan, just so we're all clear, because sometimes you hear Justice of the Peace and it almost sounds like it's a Marvel superhero character, Justice. But can you explain to our audience what exactly the role of a Justice of the Peace is, or why is it called that, I guess?
Well, yeah, I mean, of course we marry people. That's one of our duties. But I think when people think of Justices of the Peace, that's what they think, that's all we do. In fact, when we travel to out-of-state seminars, when we tell everybody, the other judges, that our title is Justice of the Peace, they're like, oh, so you marry people. Yes, we do marry people. But we also, our court, the reason why I love it so much is because it's basically like the kitchen sink of the judicial system. So we have a whole civil arm and a whole criminal arm. So the whole criminal arm, we handle misdemeanors from beginning to end. We are the trial judges and the sentencing judges, and our sentencing is up to 6 months in jail. So we're not sentencing on felonies. But we do handle felony matters. We handle preliminary hearings and bail settings and probable cause hearings. Justice Court also has a whole civil arm as well. So anytime litigants are disputing and having an issue $15,000 or less, that goes to Justice Court. Small claims is an arm of our court, so small claims is $10,000 or less. We also handle protective order applications that are not domestic related. And of course, we handle all the evictions in the Las Vegas Township. So as you can see, that is why I call it the kitchen sink. I think I've covered everything, but I'm sure there's probably a few things I've left out.
Well, that is, you did say it's a kitchen sink. So, there is a bunch of stuff that you threw in there, and there are some other things that can come along the lines of our conversation. We'll be able to bring those up as well. But before we kind of transition, what made you get in? Well, speaking of transition, what made you get in or really feel like you wanted to go from private practice into running for office and become a JP?
Well, like I said, I practiced law for 16 years. I did feel as practicing in justice court doing eviction matters, both for landlords and tenants, but primarily on the commercial end of things, I felt there was a void in justice court, that a lot of the judges at that time were focusing on the criminal matters and not giving the civil and the eviction matters the attention that I felt they deserved. And so there was an opening in justice court. There were 2 new departments coming on that were added by basically legislation. So I ran for a new department and I won the first round. So I offered at that time, the justices of the peace at the time were doing everything. All the judges were doing everything. They were doing criminal matters, civil matters, evictions. And as a bench, we agreed that it would be the best at the time for the bench to start to branch off and start to segregate the civil cases and the eviction cases with particular judges. And that's how it's been since 2009.
That's interesting. And then, so just so we can all start on that same baseline, can you kind of talk about what the difference is about beginning an actual formal eviction process and then simply working out an early release with the landlord? What's the difference there? Just because I think sometimes those terms get bantered about a little bit too much.
Well, of course, I mean, a lease is just an agreement between the parties, whether it's written or oral. Usually it's written, but I mean, at any point in time, parties can agree to go their separate ways to resolve their differences. They can agree to let one party out of the lease, or sometimes the landlord might need the property back and maybe the landlord pays out the tenant to leave early. So there are all different kinds of alternative dispute resolution ways to go about things. Certainly there's the more formal programs of alternative dispute resolutions where you use usually a mediator or an arbitrator to resolve the disputes and try to get both parties to come together. But frankly, in the, more so on the commercial end, but frankly in the residential landlord tenant area, we do have some mediators at the Neighborhood Justice Center. But basically, the tenant and the landlord can agree to just part their separate ways. That happens a lot.
And then the formal eviction process is actually coming down and going through that process with the courts.
Yeah, absolutely. I can tell you how the formal the eviction process actually is commenced with the Justice Court. But yes, it is certainly the start of it is serving the formal notice that is required under the law.
Okay, and maybe that's a great segue of actually kind of, because I mean, I know there's a lot of us on the call. Hopefully not a lot of us have ever been evicted, but I mean, sometimes, people just get down on their luck and things happen. It's a part of life, unfortunately. So what would, since the Justice Court does deal with the eviction process, can you explain kind of what the process is? And I know that there was a change in the process last year after the last legislative session came in. I know a lot of the real estate professionals probably on this call remember SB 151. It was the tenant landlord bill, because it kind of, I know you're not going to talk poorly about anybody in the legislative branch, but I think there was some language kind of thrown in at the very end that changed some things around. So can you kind of explain what the process is for evictions and what that process looked like, after the new law went into effect in July of last year?
Well, I mean, SB 151 covered a lot of changes in the area of evictions and landlord-tenant. I mean, I knew you were going to ask me about SB 151, so I mean, I just flagged it, if you can see. I'm like kind of anal on my preparation, but I mean, it changed obviously some areas of commercial evictions. It basically removed the commercial eviction process out of 253 and into 2542. I do want to footnote that a minute. I'm going to come back to that in a minute. But it also changed hours that the constable needs to serve notices and orders of eviction. It kind of gave an opening and a closing to that between 24 and 36 hours. We could be here all day to talk about this, so I just want to talk about some big changes in SB 151. The return of personal property obviously was changed, and how a tenant can contest the return of personal property. One of the really big changes was that the sale of property, whether it's a sale of property or a transfer of property, absent foreclosure, sale of property or transfer of property, they made it absolutely clear that the lease runs basically what we learn in law school, and you probably learn in real estate law, is it runs with the land. So, if it's a month-to-month tenancy, then it's a month-to-month tenancy that's running with the new owner. But if it's a year tenancy or a 5-year tenancy, then that is what the new owner is inheriting. And everybody still has to comply with the obligations and benefits under the given lease. Services of the notice changed. They limited who could serve notices of basically eviction notices. There was a cap on late fees that the legislature gave. And I think that basically highlights some of it. They obviously, one of the big ones is for residential evictions. They changed the notice to pay rent or quit timeframe from 5 judicial days to 7 judicial days. So they did change that, and that was big. I did notice that it's still supposed to be 5 days for commercial, but there is an error in the law. So we've already contacted Legislative Counsel Bureau about that to see, because on the website it still says 7 days. So I don't think that's right. So we've been in contact with the Legislative Counsel Bureau to fix that.
So, Judge, you brought up judicial days. Can you explain what a judicial day is? Because I think a lot of us are, calendar days, business days, and then judicial days. What's the difference there?
Yeah, and that's a good segue into something that probably a bomb I'm going to drop on you all. Okay, first of all, I just want to say, don't shoot the messenger. I really am here just as a messenger. We're going to go through some very complicated and inconsistent orders and directives that have come down, both from our president and from our governor. So we're going to try to ferret through that. You'll probably leave here with more questions than you had when you came. But one of the things that the pandemic has caused is a cutback in personnel and a cutback on budgeting in the Las Vegas Justice Court. So judicial days are basically the days that the court is operational. So for instance, Henderson Justice Court, for as long as, well, I shouldn't say as long as I've been practicing, but almost as long as I've been practicing eviction law, was only open 4 days a week. They were closed on Fridays. So you could not count Friday as a judicial day in the counting of what was then 5-day notice to pay, run, or quit, 30-day, all of those things. You couldn't count it as a judicial day. Las Vegas Justice Court, up until last month, has always been 5 judicial days. So of course we don't count the weekends because the court was not operational on the weekends. It was not a court operation day, nor were the holidays. The court observed holidays. But at the end of July, because of some personnel cutbacks, the Las Vegas Justice Court is now operational 4 days a week. This is a temporary 1 year, supposedly a 1 year change that has been ordered by our chief judge. And so currently, until I think the end of July of 2021, the Las Vegas Justice Court's hours are now 7:30 to 5:30, Monday through Thursday. Therefore, Friday is not a judicial day under the law.
So that will give the tenant one extra day now from that 7-day period you said, correct?
It does give any responsive affidavits or anything an extra judicial day in the Las Vegas Justice Court, correct?
Okay, perfect.
Again, that is a temporary procedure because the court is basically, in essence, closed on Fridays, other than doing emergency in-custody criminal matters, which we also handle on the weekends. So Friday is basically considered a weekend day at this point because of cut in personnel.
Gotcha. And then, so speaking of the COVID pandemic, obviously we're all navigating through these waters. Governor Sisolak in his directive had placed a moratorium on any evictions. So can you kind of explain what happened during that time? Were there any evictions allowed, and what about, were there evictions that were in process that were actually stayed?
Yes, I mean, as of Governor's Directive 008 that came down at the end of March, all the evictions were stayed. It actually started individually with individual courts. I want to say kind of pressured by the Supreme Court, because of course this is just as the shutdown is occurring. Nobody knows what's going on by way of health and safety. The entire courthouse they were trying to shut down the entire courthouse, and they actually did. So the courts actually started to stay evictions individually, meaning the individual courts all over the state, until the governor actually could issue his directive. So when the governor issued his directive, he basically stayed all evictions of all types, whether those evictions were in process, and he also prevented any landlord or property owner from serving any new notice to vacate or notice to pay rent or quit. Any sort of notice that is the beginning of the eviction proceedings, which the notice is the beginning of an eviction proceeding, even though it doesn't initiate the case with our court. It is the necessary beginning notice for the proceeding to be valid once it gets to court. And so the governor stayed all of those. I know we're towards the end of the moratorium, and I will tell you that we've been talking about this webinar for about a month. We chose this date rather specifically. I know it's at pretty much the end of the moratorium because everything now lifts with a few exceptions as of September 1st. But we were hoping that by this week, there would be some information on any other time. Well, first of all, that the legislature would have mandated by way of their special sessions. And also if there was going to be any mandates by the Supreme Court by way of mediation or arbitration. I will talk about that later, but I guess to answer your question on Directive 008, it did stay all evictions, and then of course Directive 025 started phasing in certain evictions to be allowed, or basically lifting the moratorium in a stepped fashion. I believe he did that, I think, first of all, to ease the burden on the courts. I don't know if you all know about any of the figures that we look at, but on any regular year, and of course this is not a regular year, but on any regular year, the Las Vegas Township handles 34,000 evictions a year. The very next court that is behind us is the North Las Vegas Justice Court with 4,000. And then it goes down from there. So we basically have 10,000 more evictions than any of the other justice courts. We do over 75% of all of the evictions in the entire state. So as you can imagine, when we didn't know what was going on in the declaration of emergency, we really didn't have any idea, any educated idea of which tenants were paying rent and which tenants were not, and what type of caseload and influx of evictions we were going to have when the declaration of emergency ended. I do believe that, and I didn't have any direct conversation with the governor's office, but I do believe that the governor started to phase out the moratorium and, chose certain evictions to proceed. For instance, commercial evictions can now proceed. They've been able to proceed since July 1st. And in some people's mind, that might make more sense than allowing residential evictions to proceed. If you haven't looked on the governor's website, you may all already have this, but if you look at, it's probably can be found several places, but nevadahealthresponse.nv.gov is where all of his directives and declarations are. And the Directive 025, which actually is the phased in of evictions, allowing evictions, has a lot of other peripheral information. So it has frequently asked questions for landlords, frequently asked questions for tenants. It has helpful notes. I think it's like guidance. I think it was called guidance for landlords and tenants. It has a proposed promissory note that landlords and tenants can voluntarily enter into to try to repay the past due arrearages. And what I found most helpful was this chart, and I don't remember what they called it on the website, but it's basically a chart. It's all color coded and everything, and it, for the last 3 months, have gone through which evictions will be allowed and when. So of course we're now towards the end of Directive 025 because the earliest evictions were lifted on June 25th, which were basically the transient hotel type evictions, and then 7-1 and then 8-1. And now basically what the end result, the default result is if it hasn't been lifted before September 1st, then the entire emergency directive terminates on August 31st. So any evictions that were not allowed yet, that have not been allowed yet during this phased in process, will be allowed on September 1st, with a few exceptions federally, unless federal law prohibits it.
So Judge Sullivan, if you were saying, and So if there was an eviction in process, I mean, say we're in the process and we're in that kind of that window there, and then the governor's moratorium came down, the directives put a stay on it. Does that start where it stopped, or does that landlord have to restart that entire process again?
I believe his directive in each of those areas provides that if a tenant affidavit had been filed at the time Directive 008, the state of emergency, went into place, then you can pick up where you left off. But if the affidavit had not been filed yet, you have to start the notice requirement over again.
Okay, and we did have a little question in the chat that about the website. What we'll do, since we are recording this webinar, when we send out the recording of the webinar, we'll include the link to that website that Judge Sullivan had mentioned with the color coding and the graph. So Judge Sullivan, we talked about how when that moratorium is going to expire, unless there's that caveat if there's some federal law comes down, or if it's not allowed because of that. Going forward, September 1, what's the process with the evictions going forward after September 1st?
So one thing I wanted to mention, Ryan, is the promissory note that is attached in the governor's paperwork or the website. That is a proposed promissory note. It was worked on and drafted by a group of people from all different agencies. So from the Attorney General's office, from the courts, from legal aid. I believe there were members on there from either the Apartment Association and or the Board of Realtors, and of course the governor's office and the Nevada Supreme Court, because the Nevada Supreme Court is super involved in all this, super involved. Did I say super involved? So they are really trying to push everybody around, which is fine. They're the Supreme Court. So there's this proposed promissory note that's attached. So it's very long, frankly, but in essence, if tenants and landlords want to resolve the arrearages of the rent without going to court, and they want to try to resolve the past due payments, because I think everybody here knows, I would hope everybody here knows, it wasn't a complete eradication and forgiveness of rent. It was just a staying of pay rent. So now everybody's rent is due for the last 5 months. So that's a problem. Because when I practiced law, I used to tell my clients who were landlords, I was like, if that tenant is 3 months behind, that tenant's not getting caught up. We need to take action, because if they're 3 months behind, it's not going to be any better when they're 5 months behind. So if you use that promissory note, if tenants and owners use that promissory note does two things. It sets up a course of payment arrangement. When the parties agree to the payment arrangement under that particular proposed addendum promissory note, the landlord is waiving their right to evict for non-payment of rent under the promissory note. So basically based upon the rent arrears. Of course, if the tenant doesn't pay rent on September's rent on September 1st, then the landlord can evict for September 1st rent. But the landlord cannot evict for non-payment of rent for those arrears, because they basically become a payment schedule of an addendum to the lease. Even though it is rent, under that particular promissory note, the provision and the parties agree, if you're going to use the governor's one, the parties agree that the landlord cannot evict if one of those payments are missed. But it also provides that if one of those payments are missed, then the landlord can evict for basically a violation of the covenant of the lease. Because again, it refers to itself as an addendum, and the parties are agreeing that it's an addendum. So if the tenant does not pay one of the payments, then the landlord can proceed with evicting the tenant for failure to pay one of those payments on a violation of lease covenant. That's a different type of notice requirement, but it is a summary eviction proceeding.
So
what was sorry, I sidetracked. What was your original, what happens on September 1st? Sorry.
Oh yeah, so real quick before we move on, because I have a kind of a question on the promissory note. If the promissory note is in place, Is that enforceable after the fact as a contract? I mean, can they take them to small claims court with that promissory note?
Yes.
Okay.
Now, with the caveat, keep in mind, and that's why I keep saying, we're talking about the promissory note that's on the governor's website, the proposed promissory note that he wants everybody to use, that he has suggested in his directive, because all these people took a really long time to try to cover everybody's bases, be fair and equitable to both parties, and come up with a promissory note that everybody could live with. We were just having a discussion yesterday that, there's landlords and tenants out there that are coming up with their own agreements. Well, we don't know what those agreements say. And the courts, when we are presented with these agreements for payment of past due rent, we have to take them and consider them under the eyes of the law and under the eyes of contractual law. So we cannot say, this is the way for every landlord and tenant that enters into a promissory note, because we need to look at what the promissory note says. Obviously, it governs because it's presumably an addendum to the lease. But I'm speaking of the governor's proposed promissory note that is attached to his Directive 025.
So that official one. Okay, that's good to know, just in case people aren't scribbling stuff down on cocktail napkins, right? So September 1 going forward. Now we'll get back on the schedule here. So September 1 going forward, what is that process? And there was actually a question in the chat that actually asked, can we send 7 days on September 1 along with the 30-day notices? I mean, September 1, is it rocking and rolling?
Okay, so first of all, I can't tell you what you can do and what you can't do.
Gotcha.
I'm sorry, that's providing legal advice. I can tell you what the laws say. I can tell you what the orders say. I can tell you how they contradict each other, which we can talk about in a minute. But according to my rules of judicial conduct, I cannot tell you what type of notice to serve and at what time, because there's a lot of moving parts. And for instance, I'll just segue over here to the CARES Act, right? So we have the CARES Act that was issued by President Trump back on 3/26. So the CARES Act is only for residential properties, but it is for federally backed residential properties. So this is very confusing, if you will, as it tries to relate to what Governor Sisolak ordered, because the CARES Act basically says that if it is a federally backed property, the loan is federally backed, single family home evictions are the moratorium is extended to 8/31. Unless they're in a forbearance. If they're in a forbearance, then the eviction stays on. And federally backed multifamily moratorium eviction, once it's lifted, the lessor has to provide a 30-day notice to vacate. So that's a problem, right? Because, I think it's a problem because we've got a federal order from President Trump that says basically, okay, commencing on 8/31, you can start your process again, but you really can't start your process. You have to start with a 30-day notice to vacate. So some people are like, well, can I serve my 30-day notice to vacate on August 1st and have it expire on August 31st? And then I can rock and roll on September 1st. But the problem with that is then you have the governor's directive that says you cannot, in a residential non-payment or no cause setting, serve any notice to vacate until the moratorium lifts. So for instance, in the residential setting, the default, everything's going to lift September 1st. It's residential non-pay and it's residential no cause. But the directive said you cannot serve any notice to vacate before I say so, which he says so, and it's September 1st. So if anybody has any notices out there that they thought they were, jumping the gun, I would maybe seek legal counsel before you try to proceed on those notices. You also have to keep in mind, I'm sure, you know, your heads are spinning in trying to read not only the governor's very complex lifting of the moratorium, but trying to marry that with President Trump's order, which is very difficult, and probably hearing things about what the courts are going to do. So if you're all confused, I'll just say we're all confused. We're trying the best we can to interpret these laws, and you have different judges interpreting these laws and orders. So if you're evicting in North Las Vegas, or if somebody's evicting in Henderson, or if somebody's evicting in Las Vegas, you know, the judges might have different interpretations of how these laws work together and are working inconsistently with each other. So all I can tell you is, if, you know, hopefully there will be some guidance come September 1st on the Civil Laws Help Center website, which I can reference in a minute, but hopefully there'll be some guidance about notices. If you're going to start the process in Las Vegas Justice Court, we do have a pretty good website and we do keep it up to date. We also, part of our website is the Civil Law Self-Help Center, and that's where everybody can go, landlords and tenants, to get forms. So there are some discussions, although I don't think there's been any firm orders by the Supreme Court, there are some discussions about changing forms and adding certain mandatory language in some of the forms, whether it be a notice to pay rent or quit, whether it be a notice for hearing for an eviction. And so they're having meetings. And when I say they, I really mean the Access to Justice Commission. So there's an Access to Justice Commission, and it's made up of people from the Supreme Court, people made up from the Justice Courts, people from legal aid and legal services, Board of Realtors and apartments, and right? Wouldn't you like to be a fly on that meeting? So they're all trying to agree on what to do on September 1st. And I got a news flash. September 1st is 7 days away. As you can imagine, the main goal of Access to Justice, all of these Access to Justice Commission, was to try to get as much rental assistance out there to tenants as they could and as quickly as they could, because that really helps everybody, right? If a tenant is approved of some of this rental assistance, then it's kind of a win-win situation, unless they were just a really bad tenant and you want to evict them anyway, which then you maybe have other ways to evict them. But if it was really just a non-payment of rent and your tenant was a good tenant before the moratorium hit, and it's a win-win situation if they get some rental assistance. They get their back rent cured and the landlord gets their money, and then once they get back to work, then we're back on track. But we're reading now that the rental assistance is gone. So we really don't know. As you can imagine, they're trying to find money wherever they can, from this pot of money and that pot of money, and they're trying to take from this pot of money and going over here. And that is a big rapidly working, fluid situation.
That sounds like it. My head's definitely spinning. So for you guys to make sure you're kind of keeping track on it, I'm stoked we have you on the bench, Judge Sullivan, because you know, we got to have some folks that are actually experienced with all this. So now, when you talk about the CARES Act and you talk about backed by the federal government, one of the GSEs, if a property is owned free and clear, that does not fall under the guise of the CARES Act, correct? So if I'm a landlord,
correct. You can throw the CARES Act out. You can throw the CARES Act out the window. Commercial, you can throw the CARES Act out the window, you know. Okay, that might be giving legal advice. Don't throw anything out the window. But you didn't hear it from me. But yes, it has to be federally backed.
Gotcha. Okay, perfect. And then so with and we can maybe get into this when we talk about the mediation later on. But so the
and then also, can I also say, Ryan? Sorry to interrupt. Can I also say one other thing? You know, there was another executive order issued by President Trump, I think just in early August, that he was talking about a moratorium of evictions. Well, when you read that executive order, he really is just ordering certain agencies like HUD and FHA and Health of Human Services to basically go work on it. Try to find some rental money. Try to do this. Try to find some forbearance workouts. You know, he did say, I'm ordering the Secretary of Health and Human Services and the Director of the CDC shall consider. This is the only thing that really talks about evictions. Shall consider whether any measures temporarily halting residential evictions of any tenants for failure to pay rent are reasonable necessary. So that to me is just, he's fluffing it off on the Health and Human Services. I mean, I don't even know if they have the authority to issue a eviction moratorium. I mean, he probably does, but they'd have to go back to him and say, yeah, we think it's necessary. And I don't think they've done anything since August 8th.
Gotcha. So he kind of punted the football to some other folks and kind of putting that in there because he doesn't want to probably be the one to make the call, but he's probably the only one who has the authority to make the call is what you're saying.
Well, under these federal situations and agencies,
under that executive
yes.
order. Perfect.
So obviously if federal law conflicts with state law, then federal law is going to trump state law. Gotcha.
Okay, perfect. And then, so speaking of the CARES, I kind of want to jump in because the Nevada legislature in their last special session, they created a mediation program for the a mediation program for evictions between tenant and landlord. Can you kind of explain that? And then when you talk about the CARES Act, the money being there, because I think the idea behind that legislation was to kind of partner up at-risk tenants with federally backed funds to help them out with that. So with what you said earlier, if a tenant, or excuse me, a landlord owns that property free and clear and it's not a federally backed mortgage, do they not have access to the CARES funds through mediation?
Oh, that I really don't know, to be honest with you.
Okay.
I haven't heard that, but I can't answer that question. The money for me is like, I don't know anything about that. I'm not that much in the weeds. Sorry.
Totally cool. But the mediation process is not it's not mandatory, correct?
Well, right now it's not. Let's talk about SB 1, which is what was passed in the special session. So what was passed in the special session is basically that if the Supreme Court or the District Court or the Justice Court establishes by rule, basically an alternative dispute resolution program concerning the eviction of a tenant of a dwelling unit, all right? Any such eviction proceedings pursuant to the chapter may be stayed for up to 30 days for the parties to go through the program. So I think maybe this was, I don't want to use the term marketed, but the media may have gotten this, excuse me, a little inaccurate when they reported it. They basically, some of them reported it that the legislature issued this mandatory mediation program for evictions, and that's not what they did. They basically said, if you, judiciary, want to have a mediation program, then you have our authority to stay eviction proceedings up to 30 days. Because as you know, and as we've discussed, the counting of all these days and how long somebody has time to file an affidavit and such is very legislatively driven. So in order to be able to validly stay an eviction, the legislature felt that they needed to give authority to the judiciary to do that. But they did not mandate a mediation program. That's what the Access to Justice Commission is looking at. Of course, the Supreme Court does have the authority to do that, just like they did in 2009 during the foreclosure crisis. If you recall, there was that mandatory foreclosure mediation program. That was all Supreme Court driven.
Gotcha. And so with that, so say the Supreme Court comes down and says, okay, we're gonna make this mandatory mediation, stay the eviction for 30 days. There's also an article in the Las Vegas Review-Journal probably about 2 weeks ago that claimed a Gwynn Center study that upwards of 250,000 people or households may be at risk for eviction. If that is the case, I mean, if there's that many folks out there, they're going to be, are you guys in Justice Court, are you guys prepared to handle the influx of evictions coming down the pipeline? Because, in the chat room, there is a ton of questions. A lot of them seem fairly specific to instances. So, without you running the risk of getting into giving out legal advice, we'll kind of go through those a little bit later on. But if that is the case, if there's this avalanche of evictions, is the Justice Court going to be able to handle it all? Because as you said, these are legislatively set days. So what happens then?
Okay, so there's a couple things going on. I'm not reading anything in the chat room, so maybe it's best that I don't read anything in the chat room. Ryan, I'll let you filter that out.
All right, deal.
So for any of you, I mean, obviously Henderson and North Las Vegas have fewer judges than us, but in reality, I think I want to say the last 3 years, but don't quote me on that, we have had a full-time eviction master. His name is Judge Dave Brown. He practiced for years before becoming our eviction master. Honestly, I'm going to give you a little personal information. My under-over on him was 6 months. Not because I don't love Judge Brown, but I was like, man, I don't know how anybody can do this day in and day out all day, right? I mean, I gave him a 6-month under-over. I love him to death. And here he is like 3 years later. So God bless him. So I don't, I hear scuttlebutt from people, whether they're colleagues or neighbors or what have you. Oh, I was in front of Judge Brown and he gave me a bad ruling or whatever. Or I was in front of Judge Brown. He was really no nonsense. He applied the law correctly. So it's just like being in front of any judge. There's going to be one party that leaves unhappy and one party that leaves relatively happy. And that's just the way it is. So up until the moratorium, he was the only judge doing evictions. Well, then the moratorium hit, and then he was like, woohoo, I don't have to do anything. I mean, that's his full-time job, right? I mean, yeah, we had those evictions that were allowed under the moratorium for real serious danger to property or danger to persons or what have you, illegal business going on, crimes going on, but those were few and far between. There were some of those evictions going on, but he was screening those. Does this really fall under the exception to the moratorium? But so now they are, what the good news is, right before the moratorium hit, the Las Vegas Justice Court hired 2 new special masters. So these are judicial officers. They're masters, their decision is final. So it's not like they're making a recommendation where then the justice of the peace has to approve or disapprove of the recommendation, kind of like the referee in small claims court. It's not like that anymore. Judge Brown, by his title and by the way we've structured it in the law, his decision is final for appeal purposes, whether it's the tenant or the landlord that wants to appeal. We kind of alleviated a middle process of having to go to a justice of the peace to fight about it. But right before the moratorium hit, we hired 2 new masters. The Justice Court hired 2 new masters. Now they are cross-trained. They were hired to be cross-trained, and they are cross-trained. They are cross-trained to do small claims trials, traffic trials, our initial appearance court, which is a criminal court because it's handled on the weekends and on non-judicial days, and evictions. So Judge Zaragoza, who's our resident guru of evictions and civil, she did, I should say, try her best to train Judges Westmeyer and Ferreira, but this was like right before, they had their scheduled training like March 23rd and March 24th. So it was literally right before the moratorium hit. So I don't think Judge Ferreira and Judge Westmeyer have done any evictions. I hope they're brushing up. So we do have those additional, I mean, we know we have to basically double, triple, quadruple our calendars, but we do have the manpower, more manpower than we had before the end of March. We also have justices of the peace that can cover. What they can also do is the justice of the peace, for instance, that do criminal cases that don't know much about evictions, to be honest with you, could cover an initial appearance court if that was one of Judge Ferreira's days and we needed her in eviction court. So we are going to try our best. We really don't know what the avalanche is. I did see that article, but we don't know where that comes. That's maybe, potentially, we don't know. I mean, I think Judge Zaragoza took a very small survey of some apartment complexes that she works closely with in her outreach with the metro area commands. And I don't know who they were or what areas they were, but basically what they reported back to her was an 11% non-pay rate. I don't know what all your observers are seeing. I reached out to one of my friends who was property manager of one of the weekly apartments on Boulder Highway. And this was early on, this was in mid-June. She had a 25% non-pay rate, which frankly I thought was pretty low for a weekly on Boulder Highway, So we really don't know what we're hoping. Landlords and tenants are out there working things out, whether it be a payment of arrearages or whether it's just a parting of the ways, because the landlords need to move back into their homes because some of these landlords have lost their jobs. and their house is being foreclosed on. So maybe they need to move into what was their first home and is now their rental home, you know?
And then there was also a question about the constable's office. If that avalanche kind of keeps going down, is the constable's office going to be ready to actually take care of all the evictions?
Well, I hope so. Jeff Rogan, who is the civil attorney, he's in the district attorney's office, but he's the civil attorney for the constable's office. I mean, keep in mind, the constable's requirement for serving of notice is now legislative, right? Not sooner than 24 hours, not later than 36 hours. So legislatively, they've got to serve these notices within a window of time frame. So I can only suspect that they're gearing up, both by way of personnel and staff. I did ask Judge Zaragoza because of this, because Las Vegas Justice Court is now closed on Fridays. I did ask Judge Zaragoza what the constable/sheriff's office is doing right now by way of serving notices on Fridays. And she told me that they're not serving any notices or orders on Fridays. So they're kind of treating it as a non-business day, but I'm only reporting that what Judge Zaragoza told me.
Gotcha. All right. Well,
So there are going to be some inherent delays. There's going to be some inherent delays because of this going down to 4 days, judicial days a week. The constable then reacting similarly. And then, you know, I think Judge Brown's pretty good at getting his hearings set within 7 to 10 business days. I mean, our goal would be to set hearings in a timely fashion and hopefully not be able to deviate that much from it, because everybody is entitled to access to justice and timely access to justice. Everybody, both sides.
And do you think maybe to kind of facilitate a little bit quicker turn, will you guys continue to do the kind of the teleconferences, or will these have to be in-person appearances?
That's a really good question. Thanks for asking that. The RJC, which is the Regional Justice Center, Justice Court is like, I don't know if it's good or bad, but we're open for business. I mean, our clientele, you know, we have so many people both on the civil side, the eviction side, and actually the criminal side that don't have lawyers that represent themselves, protective orders. So it was just really difficult during the shutdown. People had court appearances. They did, you know, there was a big lack of communication. Obviously, a lot of these people don't have phone numbers that even if we had the staff to call all these people, you know, that we could be calling them, emails, things like that. So we're open for business. We are, of course, complying with COVID-19 requirements and limitations. So masks are required when you come into the RJC for not only the staff, but all members of the public. We are social distancing. So for instance, on my floor, right outside of my courtroom, the courtroom next door is a small claims courtroom. So like today, I went out to get lunch and I was coming back in at 12:45 because small claims starts at 1, and there were a lot of people in the hallway. I mean, they were social distancing, but there were a lot of people in the hallway. And I was like, oh my gosh, there's a lot of people in here. You know, you get a little anxious nowadays. I don't know what it does, but you know, you get in a group of people and I had this feeling come around me like, oh, there's a lot of people in here. Is everybody 6 feet apart? I just wanted to take control, but I didn't. You know, I know the chief judge of the district court who is in charge of security and safety of the building, Judge Bell. Love her to death. I went to law school with her. She is very concerned with the number of people coming into the courthouse, and most of those people are coming in to go to the Las Vegas Justice Court. But she's very concerned about it because she's counting the numbers, I think at the request of the Supreme Court. We've tried to articulate to her that just the nature of our business, a lot of our people don't have lawyers. We can't be doing these blue jean hearings. You know, they're doing all their hearings on blue jeans and all these very, you know, the county won't let us use Zoom. So to me, that's the most user-friendly way to hold court. Like our Sparks Justice Court and Tahoe Justice Court, they're all holding court by Zoom, but our Clark County will not allow Zoom because I guess, I don't know, some naked man might walk behind me. I don't really know, but it's not one of our allowed platforms. So district court's using blue jeans. Well, we have an antiquated video system. So in justice court, blue jeans really doesn't work. It doesn't work effectively. And since we can't use Zoom, which is what everybody else is doing, because they're, you know, having happy hour at 11 a.m. on a Tuesday by way of Zoom with their cousins. Never mind. I digress. So we are having people come into the courthouse. So yes, evictions will be done in person.
Okay.
For now. Things could always change. It's fluid. I mean, if on September 1st, all of a sudden there's 600 people in the courthouse at evictions, the Supreme Court might lay down some rules.
Gotcha. So,
but I don't know of any rules right now.
Right. Yeah. Well, yeah. I guess the overall arching theme is that the thing is pretty fluid, the entirety of it. So, but I mean, like, again, we were navigating these uncharted waters. So, Judge Sullivan, there's just to kind of there's again a myriad of questions that are in there. They're kind of a little bit specific. Can you maybe just give a very general 30,000 foot view of a timeline of once the moratorium ends on September 1, the notices, the right to vacate, and then the constable head down? What does that timeline look like? Can you give like something along those lines?
Okay, well, putting aside the CARES Act, federally backed.
Right. This is just
that 30-day notice. Let's put that aside because that's
okay.
just a mess. Let's put that aside. And that's federal law. So let's put it aside for a minute. The question, the 30,000 foot level is very fluid as well, because what type of eviction are you talking about? Are you talking about a no cause eviction on a month-to-month tenancy? Are you talking about a nuisance eviction where there's crime being committed in the property? Are you talking about a no pay eviction because they didn't pay their September 1st rent? Are you talking about a violation of lease eviction, right? All these carry with them different notice requirements. And once the notices have expired, if the tenant files an affidavit in opposition, then theoretically the hearing, if there is no mandatory mediation put in place, a hearing should occur within 2 weeks, 10 business days. We're hoping for that, but again, that's being very ambitious. But again, because we don't know the numbers, I hope y'all didn't think you were going to come get some answers. I mean, I'll have a lot of answers. You ask me a question, I give you another question.
No, that's and we appreciate you. I mean, I'm learning so much, and I'm learning that one of the things that, you and I have kind of joked about, that you're actually the last race on the ballot coming up, because you're running for re-election, and so you're the last race on the ballot come November. So, but we kind of joke around those down ballot races are so important, because more than likely, I mean, hopefully I'm not going to get taken to federal court or anything along or up here, but before the Supreme Court. More than likely, if I appear before a judge, it's going to be somebody, like you. So that's why I think it's so important. It's funny, the DNC just had their convention last week, and the RNC's having their convention this week, and everybody's so enthralled in the presidential race. But in actuality, the races that truly affect our lives day to day and our business are the down ballot races. So you've answered the question of why I need to make sure that I understand who I'm voting for in these upcoming elections, and making sure that, I don't want to definitely do anything to impede the process of, if things are going as fast as they are, I don't want anybody learning on the job. So it's really, it's made me realize I really need to pay attention to these judicial races, because they're extremely important. So you answered that question for me at the very least.
Yeah, I mean, if anybody's going to see a judge in their life other than a family court judge, frankly, it's probably going to be a justice court judge. Given small claims, given evictions, given a misdemeanor traffic ticket, really, you're probably going to see a justice of the peace. So, yeah. Or get married.
Or get married, exactly. I've done that a few times. So going forward, we have a few minutes left. For commercial evictions, do you guys handle commercial evictions, and are they completely different than residential?
We handle commercial evictions. Of course, the summary evictions are all very, all you're getting is possession of the property. So there is a way to do an eviction in district court to also at the same time, in tandem, try to collect your back rent. But I used to do that when I practiced. It depended on what the immediate goal of my client was. But we do commercial evictions. And in fact, commercial evictions for non-payment lifted on 7/1. So I believe Judge Brown, since 7/1, has been holding commercial evictions. And, you know, there's been no, now, you know, I will say, I want to certainly impress upon everybody that if there is a way for landlords and tenants, like I say, to be a win-win situation, whether there's rental assistance out there or whether somebody filed their taxes late, but they're, you know, maybe getting a tax return or something, we have the Neighborhood Justice Center. It is a mediation center and it's free. So it's completely free. Both parties have to agree to want to try to mediate. If they don't mediate, then they just go back to the court. I always say a good settlement is when everybody's unhappy. That, to me, that's a successful mediation. When both parties are unhappy because they didn't get what they want, that's fine. But that's what you know, you're in control of the destiny when you mediate. You as a party are in control of your own destiny, frankly. There have been comments like, well, what is there to mediate? There's past due rent that's owed. You know, the landlord's not, you know, there's arguments out there that say, well, the landlord is not in a position here to where they have to mediate. Well, it depends on what the landlord's goal is. I mean, yeah, they might be owed the rent, but is their goal really to have an empty house or an empty apartment? Or did they have a good tenant and their goal is just to get rent back? So there is the Neighborhood Justice Center. If both parties want to mediate, they can call them up. They can ask the court about it, the Civil Help Center about it. Judge Brown, at times, when he feels the situation is warranted, he will tell parties, I want you to go to the Neighborhood Justice Center. I want you to mediate, and you be back next week. And if you cannot mediate with a professional mediator, then I will make a determination. Those are usually more habitability issues or nuisance issues, things like that. And he would never send parties over there that he didn't think had some sort of common ground. He doesn't want to waste everybody's time. But if it's a situation that he thinks might be fruitful for mediation and there might be common ground, then he sends them over. But I don't think that's very often.
Gotcha. Oh, well, that's good. Well, we're coming up on an hour. It went extremely quick, Judge Sullivan, because you've been absolutely phenomenal. If you wouldn't mind, is there any way you can email me the resources, the help center, all those things you talked about, and I'll make sure I include that in the email out with the recording for all of our attendees. And then lastly, before we go, where can everybody on the call, where can they find out more information about you and just learn a little bit more about your campaign so they can feel good about voting in November?
Yeah, absolutely. Well, my campaign website is easy, judgedianasullivan.com, www.judgedianasullivan.com. My CV's on there, everything I do on the bench and off the bench to help to try to improve the judicial system, the criminal justice system, because I'm very actively involved in the criminal justice system at this time. But really, you know, my background is civil. So I still am the chair of the Civil Rules Committee, and I work closely with Judge Zaragoza, who is, like I say, our resident civil judge. She was the presiding civil judge for 4 years while I was the presiding criminal judge. So we work very hand in hand. And she really is, she's on all these, as I talk about it, all these groups, right? All these working groups. She's on these working groups with Justice Pickering, Justice Hardesty. Everybody kind of has, right, their own game plan. And it's really hard because you have all these people that have a different game plan and a different motive. And the Supreme Court is trying to herd all these cats and come up with something. And as you can imagine, you can't herd cats. So yes, you can find out anything you want to know about me. My information in the community, how to donate to my campaign, everything on judgedianasullivan.com. My CV's on there, where I worked, what type of work I did, everything.
Perfect. That's awesome stuff. And maybe, I mean, you said it's kind of fluid. Maybe after September 1, if there's more directives or a little bit more clarity going forward, would you mind maybe doing another one of these for us in the next week or so, just depending upon when things are more finalized?
Well, to be honest with you, I don't think that anything's going to change in much of a week.
Well, there you go.
September 1st is, if I had to guess, if I had to go to the craps table, or I don't gamble, but if I went to the roulette table, I don't know. I would bet, this is my bet, there's not going to be a real sophisticated program of much of anything in place on 9/1. It's 7 days away, and they're still talking about mandatory mediation, voluntary mediation, canvassing of people in the courtroom. I mean, they go round and round, and then they go round and round again. It's like a merry-go-round. But again, they're just trying to serve the best needs of everybody in the public. And as you can imagine, all of those motives sometimes, well, most of the times, conflict with each other.
Gotcha.
So I guess I tell landlords that are kind of chomping at the bit to be careful what you wish for, right? Because, you know, there are landlords out there that had bad tenants to begin with. And, you know, in March, they were 4 months behind, or they had been a slow pay for 8 months. Okay, certainly there are those types of tenants, but there are also tenants out there that were paying timely. I mean, I'm a landlord. I have a property in Reno. And so I'm a landlord, and I did not expect to get paid on April 1st, to be honest with you. And I did get paid. And I raised an eyebrow. I was like, huh, I got paid. And so, I mean, I'll just tell you what I did just as a landlord. I mean, I just offered my tenants through my property manager. I just offered my tenants that if they pay, because I knew the moratorium was in place, right? So I just offered them, if you pay April, if they had already paid April. So I said, if you pay March and June in full and on time, I will cut your rent in half for July. Because I figured something would be lifting in July, and I didn't want to necessarily give a carrot up front, but I wanted to give them a carrot. So they were very happy about that. And actually my lease is expiring, their lease is expiring on August 31st, and they've decided to renew for a year. So if you can keep that type of communication open with between the landlords and the tenants, like I say, if you can resolve your differences, regardless of what it is, if it's just giving them time to vacate because they have 5 kids and they're all supposed to be on Zoom every day in class, I mean, whatever it is, you know, you're going to have more aggravation and effort and money fighting about it, frankly. It's like a divorce. Anyway, okay, I sidetracked.
Awesome, Judge Sullivan. Well, thank you so very much. I see your shirt, so I know we want to make sure you can get home and watch the game in time. Thank you so much for your time, for your insight. Everybody, please visit the website, and then once Judge Sullivan sends out those links, I'll make sure everybody gets the recording. Thank you guys so much. Go Knights, go.
All right, thank you. Go Knights, go.